Alright, so you can't have alcohol out here?
No.
Okay. Yep, put your hands behind your back. So when I run that ID that you gave me, it comes back to a male. Yeah.
What are you trying to say?
I'm not sure.
The 1st of September, 2025, Clearwater Beach, Florida. Labor Day enforcement at Pier 60 Park. An open alcohol contact produces a fictitious Illinois driver's license belonging to a real third-party individual, and a routine civil infraction becomes a 2-count misdemeanor arrest. 3 distinct legal issues define this encounter: the lawfulness of the initial stop, a significant Miranda timing failure, and a notable exercise of discretionary charging authority.
Open alcohol, Sarah 3. What up? You have your ID on you? Yeah, how old are you? How old are you? 23, let me see the picture. Where are you guys from? UT? Where are you from?
Tampa, Temple Terrace.
You obviously know you can't have alcohol. You know you can't have alcohol. Yeah, you hit it when we rolled up. I watched you. It was standing right here. Now it's over there. Okay.
Well, now, Sarah 3.
Where'd you go? UT? USF? South Florida? What year are you in?
Sorry?
What year are you in?
My final year.
Alright, do me a favor, grab that twisted tea, come over here, so we don't have to listen to this music.
Card license, the first time available. Touch the city. Hang
out right here. Yeah, because it's on your license. Is that like your parents' house?
Yes.
Where's that by? Give me a main city.
It's not pretty close to Philadelphia.
Okay. North, south, east, west?
I have no idea, actually.
You don't know where you are in relation to Philly?
No.
What about Wilkes-Barre?
Wilkes-Barre?
Yeah.
No, I don't really know that.
Huh. Alright, so you can't have alcohol out here?
No.
Okay. Yep, put your hands behind your back. So when I run that ID that you gave me, it comes back to a male. Yeah.
What are you trying to say?
What are you trying to say?
I'm not sure.
Go ahead.
Okay. So,
547, female detained at this point. Okay, so
13:41 hours. Do you need an additional?
are we telling the truth? Yes or no?
About
Your name, your
my
age.
CBS City on.
Okay, so the ID you presented me is fake, correct?
Yes.
Okay, that's why you're in handcuffs right now.
Okay.
Okay, how old are you?
I'm 20.
20. So you turned something real stupid into going to jail now.
Okay.
Okay?
Yes, sir.
Okay. Have a seat right here.
What about my phone?
It's coming with you. What stuff is yours over there? Because you're obviously in a bikini, so.
I have jean shorts and
Those jean shorts right there? Okay, do you have a bag?
yes.
Butterfly bag? Okay.
Call one of your friends.
Serious though? Like,
Yeah, call one of your friends up.
I wasn't even really like drinking it. Like, it's not even my drink.
I gotcha.
And he's claiming I was trying to hide it when I.
We're not playing around. Okay? Alcohol is legal. You're all under 21. That's illegal too. And then you want to present us with fake IDs, which is a felony. This isn't the place to play these games.
This is your bag?
Yes, and my shirt is over there. It's left. Is it that
Yeah,
one?
9.
Oh, that's not mine.
This is not yours, but these are yours?
Copy.
What is it?
It's a black iPhone.
Yeah, there's a phone in there.
You have nobody else's stuff in here before we drive away? Just his phone? Where's your real ID?
It's not on me. It's in my car.
Someone, one of the girls, come here. Help her put these on.
3274.
Pinellas County Jail. It's real nice videotaping your friend get arrested. You turned something real simple and made a stupid decision. Yep. Now I'm going to sign the affidavit. That way when we get to Pier 60. Yep. Alright, so you have the right to remain silent. Any statement will be used against you in the court of law. You have the right to talk to a lawyer. If you ever present with you while you're being questioned, if you cannot afford to hire a lawyer, one will be appointed to represent you for any question you wish. You can decide at any time to exercise these rights, not answer any questions, make any statements. You understand?
Go ahead.
I'll be here the one.
So you said your name is correct, but your birthday is
Go
not.
ahead.
What's your real birthday? Just curious. You know I'm a police officer, right? Okay. Why give a police officer a fake ID? Did you think that we could not figure out who you are? Or run at? So here's the thing. Honesty goes a long way with it. Well, it's not that serious. What makes it serious now is that you presented a false driver's license. Okay? If you were honest, this is how this would have went. If you were honest with me and said, hey, yeah, I'm 20, like, just, whatever, having fun, I would have wrote you a simple civil parking, like a parking ticket, not even criminal, and we would have been on our way. That's how this would have went.
Contact and detention are constitutionally sound. Terry v. Ohio establishes that reasonable suspicion of criminal activity justifies a brief investigative stop. An open container in a designated no-alcohol public zone meets that threshold immediately. When the license queried as belonging to a male individual and the subject failed basic address verification, the officer crossed from reasonable suspicion into independent probable cause. The Fourth Amendment is satisfied. The Miranda issue is the legal centerpiece of this encounter. Formal arrest handcuffs applied occurred at Bodycam timestamp 2 minutes 53 seconds. Substantive interrogation about the document's authenticity continued immediately after. Incriminating admissions, real identity, age, fictitious nature of the ID were produced at timestamps 341 through 345. Miranda warnings were not administered until 7 minutes and 2 seconds. That is a 4-minute gap of unwarned custodial interrogation. Miranda v. Arizona is unambiguous. Rights advisement must precede any custodial interrogation. Berkemer v. McCarty clarified that routine pedestrian stops do not alone constitute custody, but once formal arrest is effectuated and the individual is no longer free to leave, Miranda protections attach without exception. There is no gray area at that threshold. A defense motion to suppress those admissions has a viable legal foundation. The prosecution may invoke inevitable discovery or harmless error neither cures the procedural failure. Miranda advisement takes 90 seconds. It should have been given immediately upon handcuffing. The admissions forming the evidentiary basis for the second charge were produced during that unwarned window, and their admissibility in any subsequent proceeding is legitimately in question.
And then I asked you multiple times, he even asked you, did you lie about anything if you wanted to stick with your story? Maybe then if you fessed up then, maybe we would not be in this position.
I haven't been Cox operator.
My driver's to the sleeping point and on the type.
That's the one thing that two Cox operators nearby site.
Stay over there. Can you grab this on this side? No, my phone. Disregard. I said, can you drive us enough when you get to the jail?
I'm sorry, sir. Tonight.
Alright, let's go. Can't touch it. Nope, she's under arrest. Pier 60. No, Pier 60. 547 feet.
Fine.
It's going to be a 10:15 on adult female, maybe 51 to Pier 60 Park. It's for PT for an adult female.
10-4.
Would you like me to speak here and explain what's going on?
Roger.
What? And check. Yeah, it's in there. I mean,
Who got in trouble with you?
Just me, because I lied and said that I was 23.
provided a fake driver's license. Hello, ma'am. This is Officer Capone. Hi. So she had a twisted T near her, which obviously we deal with all the time out here. When we pulled up, she kind of tried to hide it behind the speaker and knocked it over. Made contact with her. This would have went a very different way if she was honest. She presented a fictitious Pennsylvania driver's license to me and stated that that was her true identity. I had questioned her about stuff in PA. When I ran it through our system, it came back to a legitimate person. Gave her another opportunity to come clean about it. She stood by that was her. So there's only so many chances we can give. And then the truth came out, obviously, once we placed her in handcuffs. So, I'm not charging her. It is a felony to provide a fictitious driver's license to police. I'm not charging her with that. I don't see the need to ruin her life with a felony, but she's getting charged with 2 misdemeanors. One being possessing alcohol by someone under 21, and the other providing fake information to law enforcement. As I told her, and I'll tell you, this would have went a very different way if she just said, yeah, I'm 20, you know. And like I said, this is not the crime of the century. It's obviously a holiday, we got a job to do, but we can't help being lied to. So if she was honest, she would have just gotten a simple ticket, and we would have been on her way. So hopefully this is a lesson to be learned here.
You know, that's the one thing I've always told her is to always be honest with the police officer.
Right. Exactly.
I know. I mean, I obviously, you know, she deserves this and earns this. Is there any, like, wiggle room? I mean, she's
The wiggle room is designed that, yeah, the wiggle room is I'm not charging with the felony. So, like, I can't sit here and be running people, and because now I potentially could be impacting this other gentleman's life that I'm running through a database, you know, because she's got an ID that doesn't belong to her, it belongs to somebody else. So, like I said, the state takes fake IDs very seriously. I'm just not choosing to really charge her with it because I don't want to ruin her life because she seems like a good kid and she's trying to do the right things. Because if I charge her with a felony, the school has to get notified. It'd been a whole disaster. So that is just right. So we want to avoid that. But I gave her multiple opportunities to come clean. My partner did. So you know, there's only so much we can do. We don't got time to sit here and go back and forth and you know what I'm saying? We got a job we got to do. We're out here. So that's kind of where we're at. So we're gonna have a van come. She's got her personal belongings. She has her phone, obviously. She's going to be brought down to the Pinellas County Jail. She'll be booked in there. She'll probably get a small bond. Unless if she wants to wait to see a judge tomorrow, she'll get probably released on her own recognizance. But she'll get a bond within a couple hours. As long as her blood alcohol content is below 0.06, which I would believe it is because she does not seem too intoxicated. But obviously anything dealing with alcohol, they have not. They can't just release people. They got to make sure they're not drunk. But I don't think that should be an issue. But once that all checks out, she'll be able to get bonded out and released. And then go from there. If I understand correctly, you guys are on the other side of the state, correct?
right.
Yeah, okay. So her friends know, they're aware. She can call, make phone calls when she's down there, so I'm sure one of them should probably come and grab her. The bond is going to be small. Under 1,000 it should be.
Okay. Alright, well, thank you.
Alright, here she is.
Hi, Mom. Dude, you're really fucked up. Yeah, you would have gotten, I know, just, real bad choice, honey. I'm not going to take you out, so we're going to have to figure it out. Okay. Alright. Every day is better.
So what they're going to have to do is, you're going to have to go to the station, and you're probably going to see a judge tomorrow. I don't know
If you wait to see the judge, they'll probably just release you. They're not going to keep you there. They're like with no bond. You'll get released on your own recognizance. No. If she waits, so how it works typically is once you get booked in, unless you commit some crazy crime, everybody gets a bond, right? So once you get booked in and go through that whole process, if you're able to post that bond, you can get booked. And you blow book, if it's alcohol related, you blow book below 0.06, you can get released right then. If she waits, everybody sees a judge the next morning that they stay in jail, and then the judge can set their own bond rules. Most likely in a situation like this, they'll just release her without any bond.
Okay.
So, but if she wants to get out like in a couple hours, she's got to post some sort of bond.
Okay.
And if you can't, say the bond is $750, just say, if you can't post that, but you want to get out, you go to a bail bondsman, usually you give them 10%, and then you pay, $75, and then you're on a bail, you're on released on bond. Pinellas. Yep, so if you just Google Pinellas County, who's in jail, if you search her name, obviously, it's not going to be there right away, obviously, because she's got to get booked in, but in like a couple hours, I would say, you can like track her and see where she's at, see what bond she gets. You know, just in case if she doesn't call you or if you're just wondering.
Okay.
So,
Thank you.
yep.
I appreciate it.
Yep. Alright, we're going to take these handcuffs off and flip them in the front of you. When you do that, we're going to have you put on this. Max, can you just unclip for me, please? Thank you. Alright. Get out now. Unlock this thing. Go ahead.
Open alcohol pouch.
Or when you want to put this on her?
Yeah, of course.
Keep it fine.
Still looking at the level 525 consumption.
Is there a legit shirt in there? Or is this legit shirts? What I remember was one baby suit in here. Okay. Oh my God, that's good. It's not doing much, but whatever. Better enough, yeah.
The officer's most consequential decision was one he chose not to make. Florida Statute, Section 322.2(12). Unauthorized use of another person's driver's license is a third-degree felony carrying up to 5 years in state prison. The evidence was sufficient. The fictitious Illinois license queried as belonging to a real, living individual, running that person's identity through a law enforcement database without their knowledge or consent. The officer declined to charge the felony within his lawful discretionary authority. His rationale: a felony record triggers mandatory university notification. The 2 misdemeanor charges filed remain legally sufficient. Florida Statute Section 562.111, minor in possession second-degree misdemeanor. Florida Statute Section 901.36, providing false identification to law enforcement during a detention first-degree misdemeanor, up to 365 days and a $1,000 fine. The subject was booked at Pinellas County Jail. Case outcome unknown at time of analysis. First-time misdemeanor offenders of this profile in Pinellas County are typically eligible for pretrial diversion. The officer receives a B+. Lawful contact, methodical investigation, proportionate charging, exemplary parent communication offset by a 4-minute Miranda gap that was entirely avoidable. The subject receives a D, deliberate, sustained deception using a real third party's identification. 3 legal takeaways. First, Miranda warnings must follow immediately upon formal arrest. Every unwarned minute of custodial interrogation is a suppression risk. Second, presenting another person's identification document to law enforcement runs a real individual's identity through a government database without consent that is never a minor act. Third, voluntary disclosure at initial contact would have produced a civil citation here. It produced a criminal arrest instead. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Street Bodycam, for even more police interaction and courtroom content.